Hello, thank you for joining us. We begin our report with one of the most historic rulings on the presidency since the powers for the office were first drawn up in the summertime 234 years ago. In a 6-3 decision, the Supreme Court's conservative justices ruled Donald Trump is entitled to absolute immunity from criminal prosecution for, quote, official acts taken during his tenure in office. But the former president and all former presidents are not immune from prosecution for unofficial acts. It's a ruling that affirms a claim that was considered outrageous when Richard Nixon made it 45 years ago. In an interview after he left office, Nixon was asked about a proposal from his aides to spy on Americans.
Well, when the president does it, that means that it is not illegal.
The 3 liberal justices on the court dissented. Justice Sotomayor wrote, quote, today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our constitutional and system of government, that no man is above the law. The case stems from an August 2023 federal indictment charging Trump for actions surrounding January 6th. He's facing 4 counts, including conspiracy to defraud the United States and obstruction of an official proceeding. The ruling puts the future of that case into question. CBS News campaign reporter and attorney Katrina Kaufman joins me now. Katrina, what does the ruling mean for that case, Jack Smith's case against Trump?
This ruling is not great for Jack Smith's case against Donald Trump and for its timeline. What's going to have to happen next is that it's going to be remanded to the lower courts, or a number of issues related to the conduct of this indictment, because Judge Tanya Chutkan is now going to have to determine what is official and what is unofficial, what can remain in this indictment by Jack Smith against Donald Trump. For example, Trump's conduct related to the Department of Justice, the Supreme Court has said is official, so he is immune from that. That can no longer be a part of this indictment. Trump's effort to pressure Vice President Mike Pence to interfere with the count of the electoral vote, the court said that that is presumptively immune. So that means that it will be the government's burden to show that that was an unofficial act. The same with the effort to create fake electors that's alleged in the indictment. There's going to have to be further fact-finding on that to determine if that is an unofficial act that can be prosecuted in this case. And further complicating things is that the Supreme Court says that motive cannot be taken into account when this is being distinguished, whether something is official or unofficial. So you can't look at Trump's intent when he took these actions. Another thing that they said that I think is very important to highlight in this decision is that official acts can't even be part of the evidence that's presented in this trial. So this also could limit the story that Jack Smith is able to present to a jury when this case finally moves forward at a trial, which is very unlikely to take place before the November election at this point.
That's thank you. That's very detailed and extremely helpful. Let me ask you very quickly, the Georgia case, how does this affect that?
So for Georgia, something similar will have to be done, where they look at the conduct in this indictment and they determine what is official and what is unofficial, what can move forward as part of this trial.
Katrina Kaufman, thank you so much.
Thank you, John.
CBS News legal analyst and Loyola Law School professor Jessica Levinson joins me now. Jessica, what presidential role was the majority in the Supreme Court trying to protect here with this ruling?
I think the president's ability to act without fear that based on every turnaround, every corner, there might be a state or federal prosecutor saying, here is your indictment. I think it's a great question because it really shows the difference between what the majority and the dissent were worried about here. We have the majority who's very worried about protecting the office of the presidency and protecting presidents in their ability to function, and again, not being subject to criminal cases that might be filed based on political motives, for instance. And then we have a dissent worried about very different things, worried about the ability of the criminal justice system to function, worried about the idea that we are elevating one person, the president, above the rest of us in society. I think the difference is really different lenses by which you view this constitutional question, but also different fears that you have going into this question.
The history of the modern presidency has been that it has ballooned since the original conception by the founders, with the Depression, the Second World War, the Cold War, the imperial presidency being a new term that we all now use. Given that and the outline that Katrina gave us in terms of what's in this ruling, who determines? I mean, it feels like everything could be considered an official act, and therefore, how does it get decided what's official and unofficial? And is there very much ground on which you could have an unofficial act unless it was just completely a million miles away from the office of the presidency?
I mean, maybe 800,000 miles away, but it's going to be pretty far away in the sense that, again, it's an important question, right? Because it's highlighting the idea that when presidents act, it oftentimes looks official. And the court really creates these three buckets, as you were talking about. So there's absolute immunity for the things that only the president can do: pardon somebody, appoint an ambassador, or, hire and fire an attorney general, for instance. And then there's this outer ambit, this next concentric circle, which is a pretty big circle. And this talks about official acts, the type of thing that a president does in his capacity as president. This isn't Donald Trump doing something, it's President Trump or President X doing something. And then we have presumed immunity. Now, then there's this other bucket, and I think your question gets exactly to, like, how do we determine the difference between unofficial acts, private acts, and those official acts? And this goes back to Judge Chutkan. And if there are future cases, it goes back to the trial court judge to sift through the allegations and try and make that very difficult determination. So
two more questions, one very quick, which is, once they make a determination, isn't it likely then it'll bounce back up to the Supreme Court because somebody will say, well, they cut the bologna too thin here?
So I don't know if it goes back up to the Supreme Court, if they're going to take it, but it bounces back. You're right. Finally, the question on the Chevron deference. This ruling last week by the Supreme Court that gave power from the executive back to Congress. Give me your sense of how the court, the majority, sees these two different things as they basically rejigger the power balance in the shared power system. I love this question because it is about rejiggering power. And so when it comes to that big Chevron case, the question was, you have a congressional statute. It's ambiguous. Now, the executive agency that is enforcing and administering that statute, if they give a reasonable interpretation, do federal judges defer to it? And the answer now is no, they don't. They make an independent assessment. So I would say I absolutely agree that it's rejiggered power away from executive agencies to Congress, but also to federal judges. This gives a lot more power to federal judges to say, I'm not so sure about that. So it's putting more pressure on Congress. And this is a theme from this court, right? Congress, do your job. Right. Well, we'll see if they can get them to do it where others have failed. Jessica Levinson, thank you so much, as always. Thank you.